it relates to, I don't. Go ahead.
I'm sorry. Yeah, okay. Chances are the officer's not going to admit that. Yeah, we coerced a young black juvenile. Of course, they're not going to say that. But but when these kids are being cuffed up, slapped around, having their head slammed into the desk by an an abusive police officer, and of course, the officer's not going to admit that they did that. Right. But these attorneys, yeah, on the court's level, in court, oftentimes, especially with juveniles, those motions to suppress statements or totality clauses, as it was once referred to, for juveniles, they don't seem to go anywhere. And this bogus confession is ultimately what weighs heavily towards getting this juvenile or person who gave a bogus confession on during the time when they were intoxicated. It weighs heavily towards them being convicted and sent to prison for an unbelievable amount of years.
Yes, sir. Yeah.
I mean, correct me if I'm...
Well, yeah, that's true. I don't practice mostly in juvenile. I know juvenile is completely different. I know that they don't get a jury trial in juvenile. Most of the stuff I do is felony, it's felony adult felony cases. So I couldn't say anything regarding that. And then also I don't know about a law. I'm unfamiliar with the law of whether or not the parents should be present. I believe they should be. But I don't know whether or not that's the law, and I don't know if that's the, so I apologize for that. I'm not familiar with that. But there's nothing more damning than a statement. There's nothing more damning, and that's that's something that has to be protected from the very beginning. It has to be prevented. And an attorney should put all their efforts into, if there's a statement made, all their efforts should be, to go towards suppressing that statement. Because that statement alone can get a person that statement alone. I've had cases where there was no statement, where they had a witness, a serious felony case where they have a witness that they can't get a hold of, or a witness disappeared, and they have gotten a jailhouse phone call. People making phone calls to loved ones talking about something that they, talking about the case of something that they did, admitting something that they did. And because of that, we've had to resolve a case that we would ordinarily would have won without that statement, because they would have had no evidence. So there's a lot of times people say things. Even when they're like I said, a jailhouse phone call that leads to their conviction. And we just have to, it's enough. One witness is the most serious crime possible. And the closer that witness being the defendant, the more likely you are to get convicted. So, and I'm assuming that adults.
Your voice is breaking up again, attorney. We have another question. Heather, you didn't introduce yourself. You want to do that now?
Yes, can you hear me?
Yes, we can.
Okay. My name is Heather Velasic, and I have been advocating for my husband, Peter Velasic, for close to about eight years now. But he's been incarcerated for 21 years for a wrongful conviction, a second-degree murder, which he didn't commit. And we just have now recently secured a legal team to come on board, and they're very well known in the advocacy world, in the innocence networking and stuff like that, because of evidence we just found that can exonerate him. So we're working on his exoneration at this time.
Thank you. Jasmine, you had a comment?
Yes. Good evening again, everyone, for the ones who just joined. I just want to say thank you, Attorney Wright, for your input. My question I don't think I really have a question for you, but I heard what you said. I'm not sure if you just didn't get a chance to speak about if you have any solutions for any of us that's on this call that still have loved ones that's incarcerated fighting for their freedom, that's on wrongful convictions. But for the ones who are on here, which is quite a few that still have loved ones that's incarcerated fighting to get back home for wrongful convictions and torture cases, I urge you all. I did put my organization's information in the chat to get in contact with me and our organization to join forces. Chicago Alliance has been around for 50 years now, and we've gotten over 100 men, hundreds of men free due to police corruption and wrongful convictions and tortures of that nature. And by doing so, I'm just offering solutions for us all. And like I advocate and fight for every day is for us all to come together as one. The system was never built for us. In order to come against the system, we have to fight and stand up against them. So I urge everyone to join forces with us, to get your loved ones' names put out there with our organization, to join these rallies that we do. And we stand outside of the courthouse. We do all type of different rallies, protests to bring awareness to each and every survivor that's still fighting behind bars to get their freedom. I can drop our next meeting date for the CFIS in the chat as well for you all who don't know about the Alliance, but you can find out what we do on a daily basis, fighting for freedom. And that is my solution that I offer to everyone that's on here that's speaking about still fighting for your loved one to come home. I feel like this is the best option to go because they're going to keep playing us if we don't stand up against them in numbers. And it takes numbers to bring the system down because, again, it was never built for us. So they're not going to change willingly. We have to demand and we have to fight.
Right. And that's a good point. I agree 1,000%. Unfortunately, I don't have, like I said, I apologize. I don't have any solutions. The only thing I would suggest is like Miss Jasmine was just saying, yeah, the numbers has to be the numbers and continue to stomp loud, join forces, stomp loud. It's a mess when it gets on the other side of, once that judge hits that gavel, it's hard. It's just such a long, it's a much harder road when it's on the other side of that gavel. It just really is.
Well, thank you for your input, Attorney. Madeline.
Yeah, I was going to say, okay, couple of things that I want to add at this point. And I appreciate what Attorney Wright has said because, like he's saying, and it's true, the best way to fight a case, of course, is before you get convicted. And unfortunately, a lot of times, especially I've seen with our African Americans, we don't know how to be advocates for ourselves. And have a really great defense counsel. It's also important to know, for example, Attorney Wright, I was talking to somebody about this. In the pre-trial phase, that's when the discovery goes on, right? Yes, so, I've heard people say that they could not get the discovery presented to them or shown to them so that they know what they're being charged with and all of the other moving parts to that. So they're in the dark, literally. And now, to that point, am I not correct that a person, whatever information is out there about you in the discovery phase, aren't you entitled to get that information or to at least to see it so you know what you're being charged with and how
Yes.
that's being developed?
Yes, ma'am. And that's initially that's an attorney-client issue, meaning that if you don't have, there's a misconception in law. People think that the attorneys are in charge of like the bosses in the relationship. Attorneys work for the clients. The clients have a right. It's the client's case. Attorneys advocate for the clients. The attorneys have to, by law, they have to show their clients every single thing that they have. They have to. Now they can't give them a copy of it. They can't give them a copy of it. You cannot discover stuff you received in discovery to your clients. You have to maintain the copy of it. You can't distribute it, but the information itself. And no judge will let a person go to trial if they have not seen, if a client says they have not seen the information against them. You can't even prepare defense if you don't know the information against you. Even if the attorney thinks he knows, he still has to present the case, and ultimately it's the client's case. So any kind of situation, if a person goes to trial and there's information they haven't seen, and I've had cases where, and this has usually been post-trial, where someone has filed ineffective assistance of counsel because information came out during the trial that the client had no idea of because the attorney never told them, or the attorney has said things like, this person's gonna come here and testify at trial on your behalf, and they never subpoenaed the person, never talked to him in the first place. And it's about ineffective assistance of counsel. Those cases get overturned and they come back. Anytime a person gets convicted, they get convicted. And like I said, I'm an attorney. And if I ever get a client to get convicted, I encourage them, when you file your post-trial motions, also include ineffective assistance of counsel. Also include it. Because you never know when an attorney makes an error, when an error that's going to be made by an attorney, that the appellate court will look at and say, you know what? The attorney shouldn't have done this, or the attorney should have did this, or should not have asked this question, or should have inquired this way. And that reason, ineffective assistance of counsel is a reason why a lot of cases get overturned on appeal. And the case that you're talking about, where you're talking about people having reviewed discovery, that's an appealable issue, and it will come back. Ineffective assistance of counsel. So and like I said, that should never be the case. They should always see every bit of the discovery.
So now let me ask you this. Okay, you said you got to be shown the discovery, but
yes,
did I understand you to say that the attorney is not obligated to give you a copy of it? You can only be shown.
Prohibited from it. He cannot give you a copy of. It's against the law for for an attorney to distribute copies of information that he's received during the discovery process. The only time a defendant has a copy of their own discovery is when they are representing themselves.
Okay. Doesn't that make it very, I mean, there's a lot of discovery a lot of times is being collected. So
Yes,
I guess the only way to deal with that, I mean, you got to sit there and be taking notes, and very copious notes of that, so that you have the best representation in your mind about what you're being charged with.
Well, what you're being charged with, when you get arrested, just say like in a felony case, when you get arrested, there's two roads to have the case proceed. It's either they can do an indictment for a grand jury, or they can do like a probable cause hearing, which is a preliminary hearing. The defendant is going to be at the preliminary hearing. If a defendant is at the preliminary hearing, they're going to bring the witness out, or a police officer is going to testify as to what they believe the evidence is going to be. So you'll hear it. It has to be there. And if the person is going for a grand jury, the defendant's not going to be there. But the grand jury itself is going to return what they call the bill of indictment. The bill of indictment says we're charging Joe Smith that on this 5th day of June 2023, Joe Smith committed the act of such and such in violation such be that he, while armed with a dangerous weapon, entered the residence of this person and committed home invasion. Now, that's going to be in the bill of indictment. That's going to be, the judge is going to hand you that. You're going to get that on your first court date when you enter. That's at your arraignment when you enter plea of not guilty. How do you plead? You have the bill of indictment in your hand. The transcripts from the grand jury, even though the defendant is not there, the transcripts are made a part of the discovery. So you'll know exactly what the person who testified, when they testified, and what they testified to. So all the information that's necessary to move your case, or to you know what your case is about, there's no reason why a person wouldn't know that, because they have to be there. And as a matter of fact, they'll read the charges out. They'll read the bill of indictment unless the attorney waives formal reading of the bill of indictment. So there's no reason why a person will not know what they're being charged with at trial. They may not know what they're being charged when they get arrested, but at trial, they have to know. They have to know. I can't see how a person cannot be. You might be aware of that.
Okay. That's important information for everybody to know.
Oh, sorry about that. Mute that. Go
Yeah.
on, ma'am.
I was also, there was something else I was thinking about. Oh my goodness. We're talking about the pre-trial section, and then when a person, now once again, as they're going through the pre-trial phase, a lot of times, and I know Attorney Wright, we've seen this happen just more and more and more. I mean, too many times. We're talking about, and I know this is pushing you into another phase that you don't, because you deal with the pretrial phase. But when a person has the option, I'll say that, of pleading guilty or not. All too often, people end up pleading guilty because a prosecutor will tell them, well, if you don't plead guilty, you're going to get 70 years. Whereas if you plead guilty, you get 35 years. Well, most times, and you can tell me, I mean, what the statistics say on that, but my thinking is premised on what I've heard. Most times people will go for the plea, a bargain, because they're thinking to themselves, well, if I don't plead guilty, I'm going to get 70 years, so I'll take the plea and get the 35 years. But what if, instead of taking a plea deal, that the person says, no, I want to go to trial. I'm innocent, so I want to go to trial. And then they end up being found guilty. So the whole point with this plea bargain issue, what I'm thinking is that the plea bargain issue seems to be, I mean, it's a tool that prosecutors use, and they're able to use it really to their advantage from what I'm hearing and what I've experienced with, even with the clemency reports that we've had to work on. People end up pleading guilty, and that's really what prosecutors want them to do, because they're saying that we don't have the time to take all these cases to trial because we would never get through them. Well, that's not the defendant's fault. And I just wonder if the tables would turn more in favor of the defendants if we had more people saying, we're going to trial, we're not going to plead guilty. I wonder what that would do for the system if more people decide to go to trial.
Yes, ma'am. Well, interesting enough, anytime I have a case where the state's attorney is being unreasonable, I demand speedy trial, meaning that running, and that if my guy's in custody, they have 120 days to try him. Every single time I've done that, the state attorney has been upset. Every single time.
Say that again. I'm sorry, I missed that. I missed something in what you just said there. When what happens?
Sorry. Every single time, whenever I have a state's attorney that's being unreasonable, with their pleas and then because attorney, that's part of the reason that you have an attorney is that they can competently advocate for, their clients and during the plea negotiations also. But sometimes you have state's attorneys that are just being unreasonable. And every state's attorney, even in cases where I've had jury trials that lasted 46 minutes and they found the person not guilty, and the state's attorney is still convinced that the person is guilty. They just built like that. When I have a state's attorney that's being unreasonable, I immediately demand speedy trial. I filed a written demand for speedy trial. This happened yesterday in Kankakee County. That means that my person's in custody here in Illinois. They have 120 days to try him. If they don't try him, they got to let him go. 120 days. The state's attorneys don't like that because they're used to having their flexibility when they make when they're setting the schedules and things like that. You don't have to worry about the pressure of time. If everybody did that, it would completely jam up the system. It would completely jam up the system. It'll make a lot of attorneys very upset. I had a murder case back in October. We filed speedy trial, and the state's attorneys filed all kinds of motions to stop it from going to trial. And when they failed in all those motions, they failed, and the case ended up going to trial. We ended up winning, and my guy was in custody had been in custody for 4 years. I represented the last 2 of those years, but they don't like the speedy trial. So if you have a state's attorney, if you have a competent attorney and he believes that the state's attorney is not gonna make any headway with the attorney, what are we waiting on? The case is what it is. Press them to put the trial on. And if a lot of times, if you press them and they put the trial on, and if it comes up that jury trial date, and they don't have their witnesses, or a lot of times their witnesses are have done bad things, or something's wrong, then you're able to get a more reasonable plea. That's a lot of times that jury trial, that threat of that speedy trial, just like they use the threat of the plea. That threat of that speedy trial can even the playing field a little bit. And also, it's not as much as the plea that is harmful to defendants. It's the multiple charges. It's the multiple charges on 19 counts. And then talking about stacking the charges, concurrent and things like that. That's a bigger threat to getting people to wrongfully take a conviction than saying like when you have like a sentencing range of 20 to 45 years and say, well, take the 20 to 25 because you can get 45. It's the multiple charges is the one that usually get people to take pleas to something that they really didn't do. So that's more of a threat.
Thank you. All right. Oh, you got a couple of hands up, Brian Vickers and then Jasmine. And then we'll take a minute to let Roxy introduce herself and Limo and the caller at 5187. Go on, Brian.
Okay, thank you. Attorney, you just touched on...
1 minute, Brian. Go ahead.
Okay, you touched on a very interesting point, ineffectiveness of defense counsel. Okay, now a lot of cases in Cook County, one of the reasons that wrongful convictions happen, or one of the main reasons, is ineffectiveness of defense counsel. Now, a lot of people don't know this, but there's a case called People versus Strickland. And in that case, it set a very high watermark for any inmate on post-conviction appeal, on seeking post-conviction remedies anyway, to be granted a new trial based on that issue, ineffectiveness of defense attorney. Now, I guess what I'm asking is there a way that bar could be lowered so people who have that issue can actually be granted a new trial or win their case? Another thing is defense attorneys. There have been defense attorneys that have slept during trials or who were not mentally fit to represent anyone during trial. And yeah, is it ineffective? Yes, but for whatever reason, it doesn't seem to warrant a new trial. Now, why is that?
Well, ultimately, and sad to say it, you're responsible for who you hire. You're responsible for who you hire, but you have to make sure that you hold your attorneys accountable in every phase. Every phase. The attorney, like I said, the attorney works for you. You don't work for the attorney. You have to hold them accountable because any slipping at any phase can end up taking away your liberty. So you have to hold them accountable. You can't to answer already with an attorney that you know that's incompetent. You're only putting your own freedom at stake. You know, so many people I've known, so many people I've seen in the hallways of 26 in California for years, you know, hired because they think this person's a name, or they think this person has a reputation with the judge, or because they like their suit. You know, they think that they have a, you know, there's some reason they're misguided by something that's not beneficial for their case, has nothing to do with the facts of their case, or how much the attorney's going to advocate for them in their case. It's hard. Appeals are very, very hard. It's hard to get a conviction overturned. And ineffective, and I've seen more convictions come back ineffective than anything else, ineffective assistance to counsel than anything else. But even like you said, that's very difficult too. So when you see you have you know, what I've always encouraged is that, especially when it comes to like a public, this happens mostly with a lot of times with public defenders. I would make sure a client or a person, make sure the court knows, put it on record. The attorney hasn't seen you in 6 months, and you've been in jail, and you're missing something. Say it on the record. Put it on the record before the conviction. Make sure they understand that they're forcing you to go to trial and you're not comfortable because the attorney hasn't done something that you're supposed to do. Put it on the record. Put it on the record before. Don't wait till afterwards. Put it on the record before, so then when you say it afterwards, then they'll say, hey, you guys knew that this was a possibility because they said it before, you know, you knew going into the trial. If they just say it before the trial, say it. Say that they have not seen the discovery. They have not reviewed the discovery. The attorney said this person's going to testify. Even before, I've had cases where I've gone to trial, where set for trial and go to voir dire, and like some of the smaller counties out in Illinois, and there's no minorities in the jury pool, none.
Wow. All right.
Well, you know what?
I'm sorry.
I can tell you, Attorney Wright,
Yes, ma'am.
some of the things that you've said today, if a number of the people on this line who have loved ones incarcerated, if they had heard all this stuff prior to their loved ones ending up in prison,
Yes, ma'am.
the tables would have been turned totally different.
Yes,
I mean, I'm hearing stuff that you say we could have a little pamphlet.
Yes, ma'am.
Just premise on what you said today.
We need it. We need it.
Desperately need it. I'm gonna put in a request to you for the record. Why don't we write a pamphlet about this with this conversation and start developing it, because people desperately need this kind of information.
Yes, ma'am.
Absolutely.
It doesn't happen. The sad thing, like for me, and like I said, I've traveled all over the state of Illinois fighting cases. It doesn't happen to other cultures. I don't know what it is about, like particular minority culture, where these cases are. You know, I know wrongful convictions happen, but some of this lack of information, or some of this hiring an attorney on reputation, not holding people accountable at every phase, not putting your problems on the record. It doesn't happen in other cultures. It continuously happens in disadvantaged communities, or communities where people don't have the means. I don't understand that.
Let me tell you something. I'm gonna tell you what I think it is. And this is Madeline Sanders saying this. Our people, a lot of times, when we go into these courts, a lot of times we don't have the same level of education, possibly, as the people on the other side of that gate, the attorneys and the judges. And then, you know, like I know, and like some of us know on this line, Ken, that, you know, the attorneys and the judges and those people, when they're talking, they might be talking like they think they're in a doggone law school or some other kind of forum or something. In other words, they're trying to talk above the defendant's level. So the defendant is sitting there scratching his or her head, like, what the hell are they talking about? And so now this person is feeling intimidated. And then one of the other sad things is a lot of times with African-American people, and we're dealing with Caucasian folks, a lot of times there's an intimidation factor that's in the picture. They may not want to admit it, but it's there.
Yes, ma'am.
You got two hands up, Madeline.
And Candace said he had to leave at 7 o'clock. So, and it's 2 minutes after 7 right now.
I got another 5 minutes.
You got another 5 minutes. Okay. We're gonna have to continue this.
All right, you got Jasmine with her hand up, and then Levette.
Didn't have my hand up, Wanda, but I couldn't find the hand up button.
Oh, okay.
I said I wanted to ask a question quite a bit ago. So Jasmine, you know,
Okay,
whatever
go ahead.
Who, me or Jasmine?
Jasmine had her hand up. I didn't know you couldn't get your hand up. I'm sorry.
No, if that queen has a question for Kenneth, right? Please, anybody, if he has to go, ask y'all questions to him first, and then I can go after, because I don't have a question for him.
Thank you,
Go
Jasmine. My concern as I'm listening to everything, my son was also wrongly convicted and wound up having a violence against the police as on his record because they put him in a chokehold and he bit the police so he could live. But my concern is how we deal with this politically when we go into we go and we cast our ballot and cast our vote for the judges. Most of us go into the voting poll, the voting booth, not knowing who the heck the judges are. So I think that's just an education that we don't need to start on the day of election. And we need to know who these people are and how they advocate and how we can come together and make sure that people are sitting with the black robes on that are advocates for us. That's all that I wanted to add.
I'd like to answer that question for you.
Can I have Anthony, Madeline, before you can I wanted to hear what he had to say.
Okay, yeah, go ahead.
Attorney.
Yes. Oh, okay. Yeah. That is extremely important who the judges are. All the judges are either run by election or they get appointed, but they all have a background, all of them. And if you've been in the state attorney's office long enough, if you've been around, you'll know that it's a natural transition from going to the state attorney's office to the judge, either by appointment or by an election. It's a natural transition. You have to know your judge's background. There's certain judges, and some of them, when we hear the judge's name, we know the outcome of the case.
Wow.
It's important. It's important because you can only get 10 days. This is another thing. I'm glad someone mentioned this. After you get charged and you go to court, you have 10 days, only 10 days to substitute. Certain judges will back a police officer under every circumstances. Certain judges are ex-state attorneys. They come from a long line of state attorneys. They're going to, if you have a case, if it involved a police officer, you're going to get convicted. You have to file a substitution of judge. It's automatic within 10 days in Illinois. Automatically have to give it to you. No questions asked. You cannot go to, you have to know who those judges are. And then of course, when you're voting, do the research. All the judges, like I said, you can't come directly out of law school to run for judge unless if you're over 35. But most of them have a background. Look and see what their previous work is for. See what organizations they're part of. If they come from the state's attorney's office, there's a lot of chance they have a great relationship with police officers. And like I said, I've had cases where I had 43, 46 minutes. A jury found after 4 or 5 days, a jury 40 some minutes not guilty from close of evidence and to verdict, 46 minutes, and the state's attorney is still convinced that they did it because they're just trained that way. In their defense, they hear a lot of gruesome stuff, just like police officers hear. It's not an easy job, but they're charged with carrying out justice. Justice doesn't always mean conviction. Sometimes justice means not charging someone. Sometimes justice, means, voluntarily dismissing the case. And a lot of times they get jaded by that. And so that's the type of stuff that people have to look at when they're voting for judges too. Or whoever the nomination for your party. Don't, look at their background. A lot of us are familiar, and we remember 30 years ago when people came after Clarence Thomas. And some people went to his defense and saying that, they're just doing that because of the color of his skin. When it comes to Miss Hill. And then it turns out, and you look for the last 30 years, as far as advancing the agenda of minorities and disadvantaged communities, there's no judge that's been as harmful as Clarence Thomas. None.
Right.
None.
Wow.
And if we could have did that all over again, people should have stood up, and they should have stood up, for Miss Hill, but they should have, just looked at his background. Don't look at his face, look at his background. Mm-hmm. And that type of stuff. And we do the same thing here still today. We look at judges and we look at their background, look at the color of their signs, look at their last names. Look at how many signs they have and things like that. We don't do our research. And a small town that I'm from in Kankakee County in Illinois, the Republican judges have run unopposed. Unopposed. They don't even put up candidates against them. So that type of stuff there should never be a judge running unopposed. Never. Never be a judge running unopposed. Just because you can't please everybody.
All right. Well,
there's one other thing I want to say too, to add to what Kim was saying, and that is, and a lot of people really don't know this, and let me frame it this way. If a judge lodges charges against you and you say, okay, maybe they want to charge you with aggravated robbery. I'll use that as an example. And maybe you didn't have a gun. Aggravated means you had a gun or a knife or some kind of weapon. And maybe you didn't have an actual weapon, like maybe a gun. Like I know somebody who did not have a projectile, i.e. a gun that could shoot and hurt someone. He had a toy gun to commit robberies. Okay, totally different. Mm-hmm. We challenged the prosecutor on that because we knew that was an incorrect charge to try to charge this individual with aggravated robbery when it was simply robbery because he had a toy gun. Now, I talked, and so we challenged that, and the charge was changed. It was reduced. That's what happened. I've talked to a couple of lawyers who said to me, I can't challenge the prosecutor. And I said, oh, yes, you can. That is not true. If you know that you're not being charged correctly, if they say, if a prosecutor says that you have a weapon on you and you haven't shot it, it's sticking out of your pocket or something, they claim that that happened. But you said, I didn't even have a weapon on me. They cannot charge you like that. And you have to challenge that prosecutor. And they must change, if they've already charged you with unlawful use of a weapon, a UUW. If they've done that, you have to challenge that and say, no, you can't charge me. You can't charge me like that, and tell that lawyer, whoever's representing you, you've got to challenge that prosecutor.
Right. Okay, I got time for one more question before I have to go into the graduation. If anybody has any other questions.
Madeline, I only have a really quick question because we had a friend of mine be appointed to a Supreme Court Judge C. My question to you, attorney, is it's fine to see these judges at campaign time, but is there any way or is there any strategy that we can use as community activists to have them come out when they're not running for a seat? Or is it only during campaign time that you can really engage them?
When moderate to severe ulcerative colitis keeps flaring.
Meaning like how? You mean like a sitting judge or someone that's running for judge?
And my best friend was just appointed into a seat of a retired judge, right? And does she out into the community? What we're, I'm on her campaign. Yes, we'll campaign because she still has to run for that seat. Got it. But I'm asking her and the other judges that are around her, why can't you guys come in the community when you're not running for the seat? Why can't our community come to know you? And like you said, do the background. We know a lot about you when you're not needing our vote.
Right. Well, I know in Illinois, you vote for when you're talking about an election, you vote for those judges. Those judges just run for retention after that, and there's a lot of ethical reasons why they don't let judges participate in politics, with the exception of running, because I guess they're real conscious about affiliations. So most of the times, the things that judges are allowed to do, or if you're really trying to understand or get to know the judge, if you have a person, the judge is, you have to go see what events they're involved in. What kind of events? Like, say for instance, like if I want to learn about a Supreme Court judge or something, or I can go to if they're teaching, they have, if there's organizations, if they're teaching at some event, if there's some kind of like social, some kind of judges event, some kind of bar association event which they're teaching a class or they're speaking, you can ask questions and things like that. But it's really hard when you're talking about the judicial system, when you're talking about judges, it's very hard to for them to be out as much as any other politician, anybody else running for office. It's very difficult. And then a lot of times, because the judges don't make, because there's not a lot of money itself, because judges don't make a lot of policies, don't make any policies, they just kind of follow the law. So we don't get the big backing of of all the publicity and stuff. Very on the Supreme Court level, you do for the most part, maybe even the appellate court level, because there's like especially here in the Midwest, there's a lot of issues. When you're talking about abortion and things like that, where we need to where we're it's that seventh Supreme Court judge is a deciding judge, maybe a 4-3 liberal leading court. So that type of thing, but it's only for those issues, and it's really never for any other issues. So you don't get a lot of opportunities to meet the judges in that regard. But if you go like to the Bar Association, like Illinois State Bar Association websites, there's a lot of judges are doing a lot of things, not necessarily in the community like other politicians. Like they're not going to go to like cookouts or like marches against violence or something like that. But they do, give speeches, and they do, teach classes for like legal training and stuff like that. That a lot of people, that you can meet the judge there. But it's terrible because it's so important. It's so important, to be able to meet them. But let me just piggyback on your point regarding the elections. There's so few. There's so many people, the disadvantaged communities have the lowest voter turnout rates. If people turn out to vote, and I know, like I said, that's working in collaboration with other organizations too. If people turn out to vote, if they do their research on these judges, people running for judges, and they turn out to vote, there'd be so many judges, so many hanging judges that would never even be on the bench. There'd be so many hanging. We had a situation here in Chicago where we had, our last mayoral election a couple months ago, and we have the millions of dollars are spent on the front runner from the primary, but the brothers and sisters came out and voted. They came out and voted. They voted against all that money, and they voted for the person that they thought would best serve their community. They showed up and vote, and it was an upset. And that can happen at every single phase in every election, from their commissioners all the way to the Supreme Court, if people show up to vote. And unfortunately, most of our judges are from elections. And if people don't vote, the only person they got to please is the people that vote. And if you don't vote, you don't get pleased. Okay. So I'm gonna leave my my email address if anybody wants it. I have to run into this graduation. It's right. It's Ken KEN 4 FOR Justice at Yahoo. So if you guys have any questions or anything like that, please feel free to email me, Ken4Justice at Yahoo. I'm sorry I have to leave early, but I would, if invited, I would definitely love to come back and help in any way I can with this, with anybody's journey. Okay. So I apologize for the graduation.
You said Ken, what is it, attorney?
Ken4Justice.
Okay.
Ken4Justice. Oh, no, at Yahoo.
At Yahoo. Okay.
Yeah.
I'll put it in the chat.
Justice. Okay. Have a good day, everyone.
You as well. All right, ladies and gentlemen, thank you for joining. And we're at the conclusion of our show. I'll put, there's information in the chat. I will include.
Wanda,
yes, ma'am.
I just wanted to say, I'm gonna find out about that the organization. There is an organization that was founded a few years ago that actually has individuals who go to various courts and watch how the judges perform.
Mm-hmm.
I'm going to find out about that organization and get the name. And then when we have our next event, I'm going to have the name of that organization to pass around because they're doing some very viable work. They actually go and sit in the court and watch what judges are doing. They go into criminal courts. Because both of them at one time were, the women, it's two women who started the organization. They either one or both of them at one time were incarcerated. So now they have become advocates for making sure that judges are on the bench who are compassionate, and that there are individuals who want to do the right thing by individuals, especially African Americans and Latinx people.
All right. Well, thank you. I'm sorry we didn't get to you, Cynthia, but you want to make a statement before we go?
I just wanted to quickly say that's what we do, is we go to the parole board hearings for the lifers and we take notes, and then our judges are appointed, but the parole board has a lovely, lovely way of appointing a former parole to a judgeship. And then we watch, really, did you prosecute that case? Oh, gee, your husband's the chief of police and now we're getting all this done? Wow. So we actually have people take notes, and then we go into the governor's council and we testify at the State House about the judges, about the parole board, but we have it documented and the parole hearings are recorded. So we quote what these people say and how corrupt they are. So that is, yeah. So
that's
invite
interesting.
me to the next meeting.
Yes, we're gonna have to have you back. We're gonna have to have you back. Thank you, everybody. It's been a wonderful discussion. I really enjoyed it.
Excuse me, I'm sorry. What organization are you affiliated with?
So I'm affiliated with CELWAP, Campaign to End Life Without Parole, but also Parole Watch. And what we did in Massachusetts is we kind of all joined, we made a governor's council advisory board too. So we're an arm, so we keep our nose in everything. We're watchdogs for everything. So we're working on Campaign to End Life with Parole, but we see something corrupt going on. And then we posted on a website, the background of the judges, the background about the parole board. You have a right to know that.
Yeah.
So we're kind of like, yeah.
All right.
All right.
Thank you. Put your information in the chat so that people can contact you if they want to. Hey, Triple P, let's let you close us out. What did you have to say?
I was just going to ask what was her information?
Oh,
she's
I just
East
asked her to
Coast.
put it in the track.
Okay, that's fine. Thank you, Wanda.
Thank you. Madeline, take us out.
Okay, well, I want to thank everyone for coming on here today. I see that Reverend Maverick made it, and thanks for coming on. And to each of you, I'm not calling you by name, but I really appreciate the fact that all of you who came on did so. And I think that the dialogue was wonderful. I think it was Attorney Wright did a phenomenal job in presenting
Absolutely.
very valuable information. And we know that, in fact, for a lot of us who have, like I said earlier, who have incarcerated loved ones, if you had heard this information prior to that loved one ended up in prison, that loved one probably would not have gotten locked up. So I know there are other parts to this, and I'm going to ask Ms. Carter right now if we can do a part 3. We did
Yes,
part
ma'am.
2 today.
Yes,
We can
ma'am.
do a part 3 next week.
We'll schedule
If,
it.
and I'm gonna get the email information out. We'll get it out earlier so you know what the topic is going to be and who the guest is going to be. And if anybody has a guest that you would like to see come on here and talk about some area of the criminal system, let me know, and we'll make it happen. Oh, and by the way, here's an announcement for you, hot off the press. And some people may say, "Are we crazy?" But yeah, I'm crazy. Dr. Cornel West. A lot of us know of Dr. Cornel West. He's a he was a professor at Harvard and Yale. He's a political person, very activist, very he's a straight up brother, I believe. Well, he announced this past Monday, June the 5th, that he is going to run for president of the United States.
Oh.
He's running under the People's, what he called the People's Party. That's fine with me. I've been saying for a long time, neither the Democratic nor the Republican parties have done anything in the best interest of Black folks. So now that's where I am about that. And his main platform issue is to end mass incarceration.
Oh.
Okay.
All right.
Now, Black folks all over the United States, we need to get behind that brother, because ain't nobody else talking like that. Nobody.
All right. All right. Well, thank you, Madeline. And as I said before, ladies and gentlemen, have a great day and thanks for joining us, and we'll see you next week. Thank you.
Okay.
Bye-bye.
Bye-bye.
Bye.